So I will get to Mr. Fortin's sub-amendment. But I think, with all due respect, it mischaracterizes what's gone on in this committee. So what is in G2, from my point of view, is the original offer of the bill, and I know from very quick consultations just now with Ms. Collins, reflects the testimony that we heard and reflects the consultations that took place. So it's not true that this appeared from nowhere. And there were always two approaches to the bill, to have a more exhaustive list in the bill, or to have those things in prosecutorial guidelines. The original bill suggested they would be in prosecutorial guidelines, not in the bill. We heard testimony on that. It's not that we've never heard about this. And so I do not believe it is a complete rewrite of the bill, and I believe it addresses many of the things we heard in consultations and in testimony before the committee, in particular for the survivors of coercive control. And I know we can all imagine scenarios, but in fact, we have coercive control being used by male partners against their female partners very extensively in this country, and it is almost always, in cases of femicide, the precursor to femicide. So it's a crisis that's going on. And yes, we've been dealing with this. I made my first attempts to bring this to the committee's attention 4 years ago. However, we knew the amendment package was coming, and I believe we had time to have a look at it. I think this package does some important things, and the concerns that were raised about the amendment about whether it should be 2 years after or to 5 years after. This amendment goes with the word former, which will include even after 5 years if a judge thinks that's appropriate. So it has addressed that concern which was in that amendment. I could go on with a number of others. I think there's two really important improvements here, and that is the test of what someone would be reasonable to believe. That's something we heard from survivors and we heard from other experts. And we've also had, in the intervening 3-year period, the benefit of experience in other jurisdictions, which this bill reflects. And the final one, I think, which is most important to me, is in subsection 3 of G2, which introduces the vulnerability clause, which should help address the very serious concern that many had that this bill could be used against the victims of coercive control by a controlling partner. And the vulnerability test that's introduced here, I think, largely helps answer that question. So when it comes to the specific sub-amendment of Mr. Fortin, I think it has an inadvertent consequence, which would be to change the arguments in the initial cases of coercive control to be about whether criminal acts were reasonable or not. And I don't think that's a door we should open in this committee. I accept the testimony of our experts that this bill does cover the reasonableness in 2 other places, and it narrowly applies them to the 3rd category and not to the criminal acts. So I would be opposing Mr. Fortin's amendment, and I would be urging us to move forward. I would reject the arguments this is a completely new bill and came from nowhere. It came from the consultations and the testimony that we heard before this committee. I believe it's a better version, and I believe it will more effectively address the concerns of those survivors we heard before this committee. Thank you.
Thank you. Mr. Van Papta.
Good, thank you. Thank you for your testimony. It's very clear, very helpful. But I have 2 questions. First of all, related to Section 264.01 A and B, the intent section, or the mens rea section. And I think that you were saying that this wording does not require proof of actual victim fear. It's an objective test. And I accept that on face value. But then I look at subparagraph C on the next page, and you use the word could reasonably expected to cause the intimate partner to believe. So what's the difference? Like, why are you using that phrase could reasonably expected to cause the intimate partner to believe in Section C, but not also in A and B? That's my first question. And I'll just throw out my second question here. Following up on what Mr. Moore was saying about having this list, 7 items under subsection C, and my fear is that, you know, when you draft a list, maybe you're missing something. Maybe, you know, maybe there should have been, instead of 7, there should have been 8 or 9 or 10 examples, because sometimes by including a list, you're limiting the scope of the bill. This came up in a study earlier this session in October on S12, the Sex Offender Registry, and Dr. Robick, Federal Ombudsman for Victims of Crime, and Professor Benedette they were concerned how judges were misunderstanding sexual offenses, and they were worried about rape myths creeping in. And they said Parliament could respond by setting out a list of factors for judges to consider. We put forward a motion to that effect, and Mr. Maloney had this to say. I remember the evidence because I think I was the one who actually asked the question, but in my experience, the more you include, the more you exclude, because crafty lawyers will see a list and then argue it's exhaustive. So that's I thought it was a good comment at the time. You almost convinced me to vote against her own motion. But he can comment on that if he wants. That's not the point. My question is whether, taking a look at paragraph C, if we take out the words between the hyphens, including conduct listed in any of the following subparagraphs, and then exclude all the subparagraphs, have we completely gutted the intent of paragraph C, or is it still effective?
So thank you, Mr. Van Popta, with the two questions, and I'm now going to ask Madame Levman to please comment on those from a technical perspective.
Yes, well, paragraph C is obviously creating a non-exhaustive list, and that's being informed by what we heard during the course of Justice Canada's September-October 2023 engagement, as well as much testimony before this committee as well. If my colleague Ellen, could you provide the committee with some information on what the concerns were of stakeholders and why they felt an illustrative, non-exhaustive list was critically important?
Thank you. So of the stakeholders who engaged and supported or engaged in the alternative for a course of control and fence, one of the significant concerns was implementation, law enforcement, criminal justice practitioners, and including a list in the offense itself would help guide the application but not limit it. It would ask criminal justice practitioners to look at this type of conduct or similar conduct. And they also referenced the human trafficking offense, which has such a list that the Ontario Court of Appeal has since developed further indicators for. So it did not limit it. It has continued to expand as they see new cases and new abuses of vulnerability.
That sort of answers my question, but my question really is, have we completely gutted sections, paragraph C, if we exclude the list? Just get rid of it altogether, including the words, including conduct listed in the end of the following subparagraphs.
I guess what we were trying to imply, but I'll state it directly now, is that if you were to do that, that would be inconsistent with what we've heard from stakeholders, including survivors who wish to see their lived experiences in the legislation and feel very strongly that criminal justice practitioners need to know what types of conduct, that more subtle forms in particular, not the violence and the sexually coercive stuff, but the more subtle forms should be highlighted in the legislation. So if you were to remove that, you would no longer be responding to stakeholder concerns in that regard.
As we are not responding to Dr. Robick's and Professor Benedette's concerns in the previous study. But my first question was, why the difference in wording between 264.01 A and B and C? The could reasonably be expected to wording. Why not have it in all three subparagraphs?
Because sub 1, 264.011, A and B articulate the mental element of the offense. So that's about what's going on in the accused's mind. And if you look at Scotland's approach, you'll see that it's very, very similar. Scotland uses the concept of harm. We use the concept of safety in the criminal code. I believe they're meant to capture the same type of conduct, but the way in which the intent element is crafted, intent to cause a particular effect, and reckless as to whether the conduct would lead to that effect is the same. So that's the inquiry is about what's happening inside the accused's mind at that stage. Then when you move to the act element, you're looking at the actual conduct itself. So, for example, monitoring a person's finances, well, we all do that. And when we're in partnerships, we do it for each other often. But that cannot constitute prohibited conduct for the purposes of this offense unless it could reasonably be expected to cause the intimate partner to believe their safety is threatened. So that's where the objective element occurs. Now, evidence of a person engaging in the prohibited conduct, whether that be the more subtle forms or the violent, sexually coercive forms, from that type of evidence, courts can infer the mental element, intent, for example, to cause a person to believe an intimate partner to believe their safety is threatened. Obviously, the more evidence you have in that regard, the easier it will be for courts to infer intent. But both have to be made out for the offense to be proven beyond reasonable doubt in a court of law.
Thank you. Madame Gladue?
Thank you, Chair. To Ms. Levman, through the Chair, I do take your point about the reasonableness being there in 2C so that it applies to all of the sort of non-criminal offenses. So with that in mind, I'm not going to support Mr. Fortin's amendment. But what I think it's important for people who are watching this clause-by-clause review to understand what happened here is that the government has brought G2 Friday morning, and G2 replaces line 6 on page 1 all the way to line 6 on page 3. Well, the only thing that's before line 6 on page 1 is the title. And the only thing that exists after line 6 on page 3 is nothing. So, in fact, it is an entire gutting of the bill, putting forward another bill, which they already had 3 years to do after the last coercive control study, and we had no witnesses speaking precisely to this bill. So I also am concerned about the process and will vote against G2 on that basis.
Okay, so having no other witnesses, we do witnesses, sorry, speakers. Monsieur Fortin, oui.
Merci, je croyais que vous aviez mon nom sur la liste.
Thank you. I thought you already had my name on your list. No, I'm not going to rehash the argument on the sub-amendment that I proposed. And the more we speak about this, more I think it would be wise to do this. But I've listened to Mr. Moore, and in the list under C, it says about a threat to actually die by suicide or to self-harm. That's under Little Roman 7. So that means that if someone says, for example, to their spouse that they want to commit suicide, or if he or she wishes to or threatens to self-harm, and that the spouse in question believes that their safety is threatened, if I think that my safety is threatened, that's because my partner is threatening to commit suicide, it then becomes apparently a criminal act. I'm finding it hard to track on this, because if someone is threatening to commit suicide or to self-harm, well, I'm not a physician, but I imagine they need help. They need to go and see a doctor or a psychologist to help them. They don't need to be told that there's a risk that they'll be sent off to prison for 10 years. I don't imagine that's what you're aiming to cover, but that's what's said here, and that's part of the issues that I raised at the outset. And I understand that my Conservative colleagues are supporting these issues, namely it's a new bill. I understand that on the Liberal and the NDP side you have worked on this for several weeks or perhaps for several months. But for the rest of us, well, I just read it this morning and that